channel, Official Joe TV. On today's episode, I'll be walking you through the legal implication of the refusal to sign an agreement. Stay tuned and let me walk you through it. So, in 2019, the Nigerian contract jurisprudence recorded a landmark principle in the case of MTN Nigerian Communications Limited versus Corporate Communications Investments Limited. The fact of the case goes thus: MTN Nigeria, with the appellant, entered into a trade agreement with Corporate Communications Investment Limited, who is also the respondent, who is one of MTN's trade partners. The agreement was drafted by MTN and sent to the respondent for its signature. The respondent then signed, but MTN did not sign and kept this agreement. Well, there is a clause in that agreement that says the agreement takes place, or it takes effect, from the date the appellant appends its signature into this agreement. Parties, however, transacted on the basis of this contract. Then MTN therefore terminated the agreement without giving the required notice, relying on the relevant clause in this agreement. Despite the respondent's solicitor's letter challenging the termination of the agreement and requesting an amicable settlement, the appellant withdrew 27 SIN registration kits assigned to the respondent. The respondent pleaded that, in compliance with the previous trade partner agreement between the parties, it had incurred expenses in procuring facilities and equipment which were of no more use to it, given the purported termination of the agreement. It also pleaded that the abrupt cancellation of orders without a formal and valid termination of the agreement has caused it a huge financial loss. At the end of the trial at the High Court, the court found for the respondent and awarded 25 million naira as damages and cost of 20,000 naira. The same decision was upheld by the Court of Appeal. Aggrieved by the two decisions, MTN took this case to the Supreme Court. Now, the legal question becomes: can an unsigned agreement constitute a valid contract? At first, none of the parties raised this issue, and it was in the course of writing the judgment that the trial judge observed that the agreement was not signed by the appellant. Upon discovery, he adjourned the delivery of the judgment and invited the parties to address him on the evidential weight to be attached to it. So, because the court called the attention of the parties that the agreement was not signed by one of the parties and asked them to lay evidential weight on it, MTN saw this as an opportunity to escape liability. It argued therefore that the agreement was worthless and that it was immaterial that MTN was the one who prepared it. The appellant's rationale is that it was one of the terms of the agreement that the agreement would take effect from the date the last person signed, and that since it did not sign the document after it was signed by the respondent, that the document was useless and could not be relied upon as a valid contract. Well, the argument was rejected by the court on two grounds. First, on the conduct of the parties, because they have contracted and they have been making profit. MTN has been making profit from this said agreement. And secondly, from the equitable maxim that equity looks at the intent of the parties rather than the form of the contract. Rejecting the argument, the court held that the appellant could not be allowed, by deliberately withholding its signature, to take advantage of its wrongdoings and use it as a weapon against the respondent. The court further stated that it is morally despicable for a person who has benefited from an agreement to turn around and say that the agreement is null and void, unenforceable, as contended in this case. In conclusion, the principle of law is that an agreement, though not executed by one party, may be a valid contract. As such, if one party withheld execution but allowed the other party who had executed to carry out any obligation under the agreement to the benefit of the party who did not execute, the agreement may still be deemed valid and enforceable, notwithstanding that execution was by only one party. By now, I believe we now understand that if two parties are getting into an agreement or plans on getting into an agreement, then one party starts to execute on his end and the other fails to go into execution. By execute, I mean perform specific action. And when this other party fails to execute due to selfish or secret benefits to be accrued from this, then if after accruing such benefit now comes out to say this contract is not enforceable or it's null and void because I have not executed on my point, and the term says both parties has to execute, well, the court will desist from looking at the terms of this agreement, but rather the court will look at the conduct of both parties towards this agreement, that who has been benefiting and who hasn't. Then the court would also rely on the equitable maxim that says equity looks at the intent rather than the form. So to this end, I would advise that when getting into agreement, we should avoid shady clauses or dealings, because at the end of the day, like MTN did, you just have to pay more damages. So this is Official Joel TV. I do educational videos like this. Please subscribe to my YouTube channel and stay tuned for more videos like this.